Thank you for staying with KTN. We're looking at the implications of the decision that President Uhuru Kenyatta made today. And of course, just 2 days before he makes his way to the International Criminal Court for his status conference, what does this mean for the country? What does this mean for the continent? Putting in mind that the African Union made it clear that no sitting head of state should present herself at the International Criminal Court. In studio, have Elisha Ongoya, lecturer public law from the Kabrak University. I have Sakaja Johnson, and of course, I have George Kegore, Executive Director, ICJ Kenya. Gentlemen, thank you for staying with me. Ongoya, I was on you before we went for the break. What options then did the president have?
One, to travel to the Hague and attend to the status conference, because there's a lawful order of court requiring this. And our listeners, our viewers must understand this. I'm a firm believer in this thing called the rule of law. Where the rule of law prevails, we have clear institutions that discharge clear functions. Sometimes we may like those institutions, sometimes we may hate those institutions, but if you are a believer in the rule of law, when an institution discharges its lawful functions, you comply. Whether I hate the presidency in Kenya or not, it's a lawful institution in Kenya. And as long as it discharges a constitutional mandate and gives a constitutional directive to me as a subject within the parameters of the law, I must comply with that directive. Whether I hate the office of the deputy presidency, whether I hate the deputy of the official leader of the opposition,
you have to comply.
So long as you must comply. The ICC is one such lawful institution in the infrastructure of institutions governing our society, one way or the other. It has issued a lawful directive that the president must be at the Hague. He had one option. The option was to present himself at the Hague.
Sakaja, the president didn't have much choices, did he?
He had a lot of choices, and I'm really surprised at the level of dishonesty. As I've said, the legal profession sometimes comes out as very subjective. It is very clear the president had options. One, the president could have appealed the fact that he's been summoned, and they've told him that he must appear. That was an option. Of course, we could have restated the position of the African Union by having an extraordinary summit. We could have asked for an assembly of state parties. We could have gone back to the AU. There are a number of options that could have been taken from the period he was told he must go.
He must go.
But what you've seen from the president is what we've always been saying. One, Uhuru Kenyatta respects the rule of law. He upholds it. He has cooperated with the ICC fully, contrary to popular expectation or opinion. And what he has shown today is that he abides by the rule of law. He set a very good example for all public officers and all Kenyans, really. It's not really something to be applauded the way you're saying that it's extraordinary, but it's something that is admirable, especially with the history we have with presidents, especially on the continent of Africa. And secondly, what he has decided to do shows a lot of patriotism. He has decided to leave the country out of it, not to go there as the president of Kenya. That is heroic.
Made that very clear.
Yeah,
Kegoro, what are the options that the president had from where you said?
I think the president had only one lawful option. All the others would be outside of the realm of what we would describe as lawful. And Elisha has already described the lawful option.
What about the option of appeal?
That is still that is still the lawful option. It's this part of the continuum of the lawful options. If you don't appeal, it means you don't have a problem with the decision that is being sent your way. So the president really had one lawful option. Anything else outside of that would have been politically difficult to contemplate, but also completely and clearly unlawful. So, we've said at the beginning that the president has acted responsibly, and that's a good thing, because, as I said before, another president in the neighborhood, given exactly the same circumstances, acted differently.
Now, which brings me to the next question. Do you think he has now set a precedent for African leaders and for the region?
I think, you see, it could be said that the president, having acted lawfully, has set a good example and has set a precedent that is worth emulating on the African continent. But the other point to be made is that the same president has, in his political rhetoric, including today, attacked the ICC very, very ferociously. It isn't particularly a good thing to submit yourself to the jurisdiction of a court and then also subject it to the kind of political attack that happened at the extraordinary summit in at the AU in October last year, calling it pantomime and so on and so forth. So I think there are mixed signals coming from Johnson Sakaja's corner. On the one hand, they say we are lawful citizens. On the other hand, you attack the very institution that you say you are submitting yourselves to. I think that is quite contradictory in my book.
Let me respond to that. You see, respect for an institution does not prevent you from correcting it where it is wrong. In fact, institutional reform is something that is always done, wherever it is. When we attack the ICC or when we point out the problems within the ICC, we go to specifics. We go to the issues of threshold of evidence. We talk about witness procuring, and all of that is coming out. And you see, the challenge we have really is that there was a political agenda. We've said it for a long time. Now we're being vindicated. You've seen witnesses saying that they were coached, they were bought. They were bought locally, some were procured internationally.
Hold on to that thought, because I want us to listen into a bite by Luis Moreno Campo. He was once the chief prosecutor of the International Criminal Court. Let's listen into what he had to say at the beginning of these cases.
Yeah.
There are no doubts that massive crimes were committed in Kenya. The issue is who is responsible here. Someone is responsible. This is my challenge. I have to prove who are the most responsible for the crimes committed, to prove it in a court of justice.
Sakaja, you maintain this was politically motivated. It has nothing to do with some of the things you were saying.
It's a political court.
And I think the first question let me explain. Crimes committed in Kenya. I think that question, I'd like Johnson Sakaja to answer that question.
Crimes are committed in this country.
Thank you.
And for us, we are really concerned about the victims. The greatest injustice you'll do to victims is to have a process that drags along 2 years that gets the wrong people, or that even tries the wrong people. The crimes committed in this country were not so neat as to have 3 people from one coalition, 3 people from another coalition, to have people who would never vied for the presidency, to have people who are not involved in the things they're accused of, and to have no shred of evidence. If there was any evidence against the president that Bensouda is saying there's no evidence, how could the cases have reached the level they have reached from pre-trial stage to this stage?
I must intervene here.
Yes,
I think there's a sense in which this script has been misrepresented severally, and I consider my civic duty as a knowledgeable Kenyan to correct this script. Bensouda has said today, the year 2014, or perhaps late the year 2013, there is no evidence.
Yes, sufficient evidence.
Ocampo said in the year 2010, there was sufficient evidence.
So what changed?
A bit of time has passed in the year 2010 and 2014, which informs the change of circumstances. And there are 2 scripts to this. Yes. I have no answer to which script is perfect. I must point that from the very outset. The first script is the original witnesses were in any event coached, and therefore they didn't constitute evidence. That's the script that I think Sakaja will subscribe to.
No, that is
whether it is correct or not is a matter pending determination. The second script is that witnesses have been influenced to withdraw and change their testimonies. That's not a script that Luis Moreno Campo, that Bensouda would want us to believe. These are 2 scripts that are still open at large for determination. Politically, Sakaja would say yes, the first script is the correct one. Professionally, I cannot, sitting in this studio here and now, submit which of those 2 scripts is because those are matters. When you hear a man in Kenya trying to fight his extradition to the Hague, there is a script that is supposed to be proved through that man that you have been an instrument of compromising witnesses. Then you hear allegations at the Hague, witnesses saying we were bribed to record evidence, to record this evidence, and the court determining that these witnesses are hostile witnesses. That's a fundamental determination by the court in law. It is too early in the day, Linda, to deceive Kenyans that one or the other of these scripts is a superior script, is a superior value.
We have been consistent on our
crimes are committed in the country.
Crimes are committed in this country. I think there is no commitment on the part of Jubilee to doing anything about those crimes. And also, even if there was a commitment in Jubilee about doing anything about those crimes, that couldn't be done until the cases facing the leadership of Jubilee were addressed in the nature of things. Because if the allegation is that the Jubilee leadership is the one that committed crimes, then it's very difficult for it to put itself aside from those allegations and then lead. You see, the Jubilee leadership has a responsibility to lead Kenya as president, deputy president. It happens that it's the same leadership that is accused of crimes. Whether or not it committed those crimes is a different question. But what that does is it makes it very difficult for that leadership to lead the country in overcoming the problems of the post-election violence, because they are the ones who are accused and have not been exonerated.
Hold on. Probably he's pointing to some of the issues that the Jubilee government should have addressed by now. Let me just finish with regard to the victims, with regard to the atrocities that were committed.
Correct.
John Allan Namu did a story, and that story is called Nowhere People. I'm hoping we can run a clip of that story.
But even before you get there,
yes,
you must realize that the crimes were committed in 2007. This is the second government since those crimes, and we'll be able to show you the difference between what this government has done in 1 year compared and juxtaposed to what the former government of Raila Odinga and Mwai Kibaki has done in 5 years. It's very clear.
This government has done much more.
Let's have the clip from John Allan Namu's story, then we'll come back.
Over 7,000 Kenyans from all over the Rift Valley and Western Kenya had fled across the border. It was early January, and the post-election violence was at its fiercest. 6 years ago, I visited these Kenyans. In one tent, looking lost and alone, I met a young Emma Wambui. She was 27 years old at the time. Right before the violence, she had lost her eyesight. Back then, she told me of a horror that she had lived through, multiplied by the fact that she couldn't see.
It was so sad and I was so confused. I didn't know where to go. I didn't know what to do. The gunshots was so scaring, and I was just like, I didn't know where to go.
She and many other tragic cases of forced displacement, murder and rape were the reason that, at least in 2008, many Kenyans believed that intervention by the International Criminal Court was necessary. John Njoroge walks his wife into their little hut early in the afternoon. It's a perfect time to give their little one a bath. Their baby is almost a year old. He is among a generation of Kenyan babies born in refuge in Uganda. They live in the Kiriadongo refugee camp in western Uganda, having fled across the border at the same time that Emma did.
Wakimbizi ambao wakati huwa tuko mahali hapa, kuna wale wanaitwa refugees na kuna wale asylum seekers walikuja baada ya sisi kufika mahali hapa. Jumla tuko kama watu 1,500.
Jina yangu ni John Wanjala na Mayengo.
Minora na Afula.
Kwa majina naitwa George Onyeke Ndungu.
Jina ni Melon Wamboi.
Na tukachipata kwamba wakang'oa nyumba zetu, ng'ombe tukachukuliwa, tukapaki bure, wakang'oa manyumba, kila kitu.
Tukaletwa hapa Kiriadongo.
Tungekuwa tumeendelea katika inji yetu sana, lakini kwa ajili ya inji ya kigeni tunaishi katika maisha ya shida.
Tuweze kuona vile tunaweza rudishwa nchi yetu.
Many of them tried to go back to their homes in Kenya, but found their land occupied by aggressive locals.
So that story was done by John Allan Namu, Nowhere People of Kenyans who are now refugees in Uganda. In studio, I have a panel of 3 gentlemen with me. I have Elisha Ongoya, an advocate of the High Court. I have Sakaja Johnson, TNA chairman, and I have George Kegoro, executive director, ICJ Kenya. Gentlemen, thank you for staying with me. Let me start with you, Kegoro. In as much as focus now shifts to the ICC and the president and the deputy president, we have a group of people who have not been addressed in this country. I was having a talk earlier on with Sakaja Johnson, and he says, we have resettled, the government has resettled all internally displaced persons. Do you share the same sentiments?
I think the biggest problem with the Jubilee government is how it deploys propaganda at every stage, hoping that that will wipe away our genuine problems. Propaganda was used to represent settlements of Mau evictees. The same statistics, if you look at the State of the Nation address, the statistics of the Mau evictees who had been resettled were used and represented as statistics of IDPs resettled. And that is used at every stage. When they came to office, one day they just declared everybody is settled, as an IDP. Today, when the president spoke in Parliament, he could no longer commit himself to that to the question of IDP resettlement, because other evidence that contradicts that exists and keeps popping up. Remember the IDPs in Nyamira, the ones who made a long march from Konate to Nyamira town? That was about 3 months ago. That was after the supposed resettlement of IDPs. The point is this: if we can't honestly talk about the problems and admit that we haven't solved all of the problems, and then honestly talk about the solutions, if we only represent, if through propaganda problems are supposed to be wiped away, then obviously the problems have gone according to Jubilee. But in reality, on the ground, it is quite different.
Sorry, I would have been happier myself just before Sakaja responds. At least if this government, you see, as a citizen, I'm entitled, whether I like a government or not, to some consistent position of that government. Some consistent, because a government is responsibility. A government must act responsibly, and I may not necessarily agree with everything the government does or says, but at least I am entitled to know the position of government. And I may agree, by the way. Yeah. Now, more importantly for me, yesterday, in this same studio, there was the Secretary of Legal Affairs, Office of the President here, who confirmed that this financial year, the government has programs for settlement of IDPs. During the same show, the director, ICT, or social media, whatever it is, Mr. Itumbi, tweeted in that all genuine IDPs have been resettled. Mr. Johnson Sakaja, Member of Parliament, confirms that they have settled the IDPs. Now, there's a mention of inconsistency, so that I cap this argument, in those three operatives who are very close to the seat of power. And that worries me as a citizen of this country who is extremely far from that seat of power.
Sakaja, what is the correct, true position? Okay.
First of all, Kegoro talks about propaganda. And usually when you lack a point, you throw issues like propaganda and conjecture, etc. out in the air. If we have propaganda, our propaganda has been superior to the propaganda you guys have been spewing from the point of the election with respect to the ICC suspects not being elected. We have won, and our propaganda is more successful. But it's not propaganda. If you look at the issues of the IDPs, in the last 1 year, we have superior information. In the last 1 year, 74,000 IDPs have been settled. Anybody who travels this country cannot see the IDP camps that we used to see. But the difference, and which is what you're trying to get, and I will help you with that, is that there are two categories of IDPs. There are the IDPs who went to camps. All of those, without a shadow of a doubt, I can tell you, were resettled. All the genuine IDPs who went to camps. But there has been the problem of integrated IDPs. There are certain IDPs who decided, or rather who had to get into communities. They went and they integrated within communities. They went to live with their cousins. Some of them have joined their uncles, their relatives. And the problem has been, from the last government, these lists have been changing. Now, government has to verify this list, because every time you, and I'll give an example of the camps, every time you close a camp, it comes up again the next day. Every time you resettle them. And I have all the statistics. The statistics are available on government websites, on any ministry. You can know that in 1 year, this government has dealt squarely with the issue of IDP camps. There is no single IDP camp in this country from the post-election violence. The only other camp that you might talk about, or the people you might talk about, who are also integrated to some extent, are those who went to Uganda. And those are facts, George. That is not propaganda. Drive around this country. Tell me where you've seen a camp.
Sakaja, hold on. Let's bring in John Alanamu. John Alanamu did that feature, Nowhere People, and he focused on Kenyans who are now internally displaced persons in Uganda. John, in studio, I have Sakaja Johnson. You wanted to ask him a few issues, a few questions that were raised by the IDPs you spoke to in Uganda.
Well, it's not really about the IDPs. They are refugees and people who are seeking asylum. I just wanted some clarity on who exactly is processing their request to return to the country, because it's been unclear from yesterday when Msambuki came into studio who it was exactly who is processing their request to return. The facts on the ground is that it's the UNHCR. Is it happening in conjunction with the government, or are they doing it on their own?
Thank you, John Allan, and for the story you've done. Indeed, the plight of those Kenyans out of the country is really sad, and it's something that must be addressed. These UN agencies that you see, like UNHCR, even Red Cross, always work with government. In the case that it is working in a territory outside Kenya, then the Kenyan embassy in conjunction with the government of Uganda then gets information from UNHCR, and I think efforts must be made to resettle them. But it's something that definitely I should get more details about if that is possible.
Yeah, because Sakaja, the confusing issue here is that it doesn't seem like there's much government input, at least from what the refugees in Kikatondo are saying. It's purely the UNHCR that is dealing with them, and that they have yet to receive any feedback from government agencies on the ground. But that's another issue. Another issue, perhaps, that even as the government has dealt with resettling IDPs, nobody is asking why it is that they're not going back to the homes that they were in originally. What's going on with respect to dealing with the deeper issues as regards social harmony and social unity?
Let me answer both questions, John Allen. You do realize that the conventions that govern how refugees are treated in other countries. I'll give you an example. We have Dadaab camp of Somali, that are Somali refugees. The government of Somalia cannot in any way just come cross the border and go to the camp and start helping those people. You have organizations like UNHCR which then do that. So it will be impossible for you to see Kenya government officials in that camp in Uganda because of these conventions. But we work together with the UNHCR and together with the government of Uganda to make sure that they're in a good situation, and when they're ready to come back home, they can come back home. Generally, John Allen, when you look at the issue of IDPs and what has been the problem over the past many years, not just 1 year, is that there are certain people who, apart from the genuine IDPs, who have been settled to a large extent, who have seen this as an economic, a way that they can make money. When they see IDPs getting 10,000 shillings, then somebody goes and pitches camp. There's a time we went to Eldoret, and a camp had been closed, and we found people in that camp. And we were with the DC, and we told them, okay, are you from around here? I said, yes, originally, yes. Then get into this lorry. We went around the town, and we asked them to show us where the houses were, and none of them could remember where they used to live. So there's also some level of insincerity, and that questions the credibility of the list that were handed over from the previous government. However, what has been done successfully in Kenya is that all the IDP camps coming from the post-election violence have been closed down to this point. The issue, the challenge which is being dealt with now, and ably so by the Ministry of Devolution, is the issue of integrated IDPs who went and have assimilated themselves into communities, who live with families, and in as much as some of them may have an economic, a way to fend for themselves, I think they also deserve compensation, and the government is going to do that.
All right, Namu, I'm sorry, I have to interject. I have to cut you short. We're running out of time, but thank you so much for sharing your concerns and some of the questions that the IDPs in Uganda had for the government, and of course how the whole process is being run. Let's look at the options that are available for the judges at the International Criminal Court. Elisha Ngoy is going to take us through some of the choices that are available for the three-judge bench. Elisha.
Well, before I point out the war, let me just point out something in context. Number one, the status conference is a procedure of the ICC that is provided for under rule number 132 of the rules of procedure and evidence of the International Criminal Court. Under that rule, there are two categories of status conferences. One is the automatic status conference once confirmation of charges has been done to set a hearing date. That was done in both the one may call the Ruto and the Uhuru cases. The second is the one that the courts hold periodically to consult with the prosecution and the defense for purpose of securing a just and expeditious disposal of cases. That's the category of status conferences that are going to be held on the 7th and the 8th. That is tomorrow and the day after tomorrow, as it were. Now tomorrow, I trust the Attorney General will be addressing the ICC judges on the status of the cooperation of the Kenya government at the ICC. Now what that means is that the prosecutor has said, and we trust she will reiterate, that she has not received optimum cooperation from the Kenya government.
And she does not have sufficient evidence. To try this.
The Attorney General will be saying that he has given optimum cooperation that he can possibly do within the framework of the available laws and material to the prosecution. Two options are available. Number one, if the court takes the view that the Kenya government has failed in its obligation to cooperate, then it will refer the case to the Assembly of State Parties for a political decision because this is an erring, it will have determined that this is a state party that is not working consistently with the expectations of the statute. If the court finds that the Kenya government has acted the best it can, but there is more that it can do, then it can order that it can renew the cooperation order.
Just hold on, Elisha. If we refer to if Kenya is referred to as Assembly of State Parties,
yes.
What are the consequences of
These are now political sanctions that are supposed to be applied, because the Assembly of State Parties is a political forum. It's not a judicial forum that acts on orders. These are now political sanctions that would follow. Kenya would have to be discussed, and Kenya would have to make its case using now its political diplomatic channels, as opposed to now the Office of the Attorney General, which is a legal forum that works with judicial institutions. So Kenya would have to diplomatically engage at the Assembly of State Parties, but the only sanctions available here, if at all, the political sanctions. And that, of course, then Kenya would have to lobby the African Union and other members, because these are political forum, to be able to work or to talk its language if and when the matter is referred there.
So under what circumstances would we renew
if the court finds that the Kenya has cooperated, yes, it's not such a failure that deserves referral for these political sanctions, but that there's still more that the Kenya government can do in the court's opinion. Then the court can renew the cooperation order and possibly set a time frame within which the Kenya government will do certain specific actions that are referred to in that case. Then the State Conference of the 8th, which the Honorable Uhuru Kenyatta has been called upon to attend. Now, at that status conference, that was the date that was initially scheduled for the commencement of the trial of the Uhuru Kenyatta case. The prosecutor has said, look, I don't have sufficient evidence. It is not the business of the court to engage in a case. They say elsewhere that if an alligator came from the sea and told you Mr. Crocodile is sick, who are you to doubt the truth of that story? The prosecution itself has told us that the evidence it has as we speak today cannot sustain a trial. So the prosecution is seeking that the case be deferred indefinitely to enable them, consider whether this further cooperation with the Kenya government can yield evidence, or whether further investigations can yield further. If the court agrees with the prosecution, then it will defer that case. The rules require that once a case is adjourned in that matter, that adjournment must be made public, and any new hearing date that will be scheduled has to be made public. But Uhuru Kenyatta will be making out a case that is unjust to keep the sword of Damocles hanging over his head indefinitely without any definite time frame. I think that's a very legitimate submission by any accused person. Working for the defense, I would say the same thing. It's not fair where a prosecution
has no evidence. Yes,
it doesn't have evidence. It is not submitting that I have interfered with the evidence. Also, any arrest against me under the charge of interference with the justice process at the ICC, then to seek the court's intervention to keep that sword hanging over my head, so that he'll be making out a case that then terminate the cases against me. So, to my mind, broadly speaking, those will be the four powers available within the fairly broad definition of what can happen at a status conference to expedite or to justly determine the matter that for the ICC in respect of the Uhuru Kenyatta.
All right, Elisha, walk with me as we wind up this. Uhuru Kenyatta, while making his address today, made several references to the sovereignty of the nation.
Yes.
Do you think the sovereignty of Kenya is under attack as we speak?
Under Article 1 of the Constitution of the Republic of Kenya, sovereignty is vested in the people of Kenya. If you read the four corners of the statute of the International Criminal Court, it provides for individual criminal responsibility. And I don't think that calling upon an individual to account can be equated to attacking the sovereignty of the people of Kenya as a collectivity. A justice process will invariably call upon people to account. Some of those calls may be manifestly unjust, manifestly unfair, manifestly uncalled for. That would amount to an abuse of the process of court or process of law in respect to that accused person. If it were to turn out historically that indeed the prosecution at the ICC compromised, bribed witnesses or induced witnesses to fix Uhuru Kenyatta, that will be a major abuse of the justice process. I will be among those rallying for the calling to account of those who are given the instruments of power at the ICC who have colluded to have done that. But that, I'd say that's a question at large. It's for the judges at the ICC, and we must defer to institutions. I think institutions and their makers in their wisdom didn't call upon the chairman of the TNA to be the one determining that question, or a member of Parliament of Kenya to be the one determining that question, or the President of Kenya in his address, the Kenyan nation, to be the one determining that question. They vested the jurisdiction to determine that question in the institution of the judges of the ICC. We must have the habit of deferring to the institution, not just in the interest of order, but also in the interest of good order.
All right, Sakaja.
You know, again, insincerity is very bad. You cannot separate the president of this country and this country's sovereignty. For two reasons. Number one, the same constitution which you teach at Kabarak says that the president, one of his duties is to safeguard the sovereignty of this country. That is one of the duties of the president.
The sovereignty of the people of Kenya. The bearers are the people of Kenya.
I mean, the country is not just 583,000 square kilometers. It's the people who make the country. It's not a geographical space. But the constitution says that he has the mandate. No one else in this, in the constitution has been given the mandate to safeguard the sovereignty of the people of Kenya. The constitution also says in that column which he has stated correctly, that the sovereignty of this country rests with the people of Kenya, but it does not end there. You should have gone on. And they can exercise it directly or through their elected representatives. You need to note that these people of Kenya, who exercise the sovereign power of the country, exercise their sovereignty by electing Uhuru Kenyatta to be the president of this country. So when you say that you can separate the sovereignty of this country and the president, not the individual, that way is gone as an individual, and the president, then you're being insincere. The president actually is a representation, is a symbol of national unity, is a representation of that expression of sovereignty that Kenyans have put there. Which is why we said, and we keep saying, that never should it be said at any place in history or in the future that the president of Kenya went to the ICC. He is not going to the ICC.
Which attracts me to your issue. What is Mr. Sakaja's answer to your question whether the sovereignty of Kenya is under attack? Because I didn't hear him answer that question at all in his very many words.
The sovereignty of Kenya is not under attack. The sovereignty of Kenya must always be protected. That is what the constitution says.
I agree. It's not under attack. That's the point exactly.
Yeah.
Kegoro.
I was going to actually start where he ended, to say the person at the ICC is not the president of Kenya, it's Uhuru Kenyatta in his individual capacity.
Exactly.
And then I was going to ask, how would then the sovereignty of Kenya be under attack under those circumstances?
If he goes as the president, then he'll be under attack.
He's charged as an individual, and he's going to be answerable as an individual. The sovereignty of Kenya remains intact at all times.
Let me give
And
an
he made it
international
clear, he said
example.
this is a personal problem.
Yes, it has always been a personal problem. The only problem is that the words of the Kenyan leadership is this is a personal problem, but the actions of the Kenyan leadership in dealing with that personal problem is very much a state. They invoke the Kenyan state in dealing with that personal problem.
Okay.
You saw what happened at the AU.
It was the might of the Kenyan state.
An international
Why
example.
would we then
3 days
summon a
ago.
special
Just
sitting
hold
of
on,
a
hold
state
on.
institution?
3 days ago.
Parliament is called.
Why would we invoke the resource of a state institution called the joint sitting of Parliament to address a personal problem? That's
Because
something that Sakaja was on the question too.
Let me respond to what I was responding to. 3 days ago, David Cameron of the UK gave a statement saying that the UK is considering repealing the Human Rights Act because of rulings of the European Court of Human Rights. What did he assert in that decision? He asserted the sovereignty of his country. But sometimes in our country we have certain quarters that suffer from some inferiority complex that Kenya cannot assert its sovereignty. Kenya is not a sovereign country, and its sovereignty does not need to be protected. It must be protected as a country. And that is why he himself said he must not be subjected to the European Court of Human Rights. That is why we're saying what President Kenyatta has done is even better than what David Cameron has done 3 days ago, and it is unprecedented internationally.
Okay.
May I say something?
We really have run out of time. I understand we've run out of time. But thank you so much, gentlemen, for coming into the studio, for sharing your opinion on what happened today. Of course, the president there putting in place Article 147, thereby making his deputy, William Ruto, the acting president of the Republic of Kenya. In studio, I had Elisha Ongoya. Thank you so much for joining us. Sakaja Johnson, Chairman TNA. Elisha Ongoya, lecturer, Kabarak University, Public Law. Thank you. And George Kegoro, the Executive Director, ICJ Kenya. Gentlemen, thank you so much.
Thank you.